Good afternoon, and welcome to this Regulatory Transparency Project webinar. My name is Steve Schaefer, and I am the Director of the Federalist Society's Regulatory Transparency Project. Today, October 16th, 2024, we are pleased to host a discussion on climate disclosure litigation against California and the SEC. Please note that all expressions of opinion on today's program are those of the speakers. After the discussion, our panel will take audience questions, which you can submit using the Q&A function at the bottom of your Zoom window. Our moderator for today's discussion is Marc, who is president of the Center for Environmental Accountability, where he leads the movement to educate Americans about the lawfulness, efficacy, and trade-offs of regulatory policy in the energy and environment space. If you're interested in learning more about our speakers, you can read their full bios at rtp.fedsoc.org. That's rtp.fedsoc.org. Thank you all for joining us today. And now I will hand it over to you, Marc.
Thank you, Stephen. I'd like to thank our three panelists for taking part in this timely discussion. And thank you to our audience streaming at the office, in the law library, or at home. Our panelists will give introductory remarks, followed by discussion, and then questions from the audience. First, allow me to situate our audience in the litigation we'll be discussing today and to introduce our panelists. As many of you know, in early 2022, the SEC proposed a rule that would, in its words, quote, require registrants to include certain climate-related disclosures in their registration statements and periodic reports, including information about climate-related risks that are reasonably likely to have a material impact on their business, results of operations, or financial condition, and certain climate-related financial statement metrics in a note to their audited financial statements. The required information about climate-related risks also would include disclosure of a registrant's greenhouse gas emissions, which have become a commonly used metric to assess a registrant's exposure to such risks, unquote. After taking public comment, which included broad pushback from the regulated community and some notable delays, the SEC finalized the rule roughly 2 years later in early 2024. A major point of pushback to the proposed rule was the breadth of the registrant's proposed disclosures as to its greenhouse gas emissions. In the proposed rule, this included so-called Scope 1, Scope 2, and Scope 3 emissions. Scope 1 means more or less direct emissions from sources that the reporting entity owns or directly controls. Scope 2 means indirect emissions from the entity's consumption of electricity, steam, heating, or cooling to power their operations. Scope 3 means indirect upstream and downstream emissions from sources that the reporting entity does not own or directly control, and may include the emissions of upstream suppliers or downstream customers. In the final rule, the SEC omitted Scope 3 emissions from the scope of the rule's reporting requirements. The final rule was quickly subject to a flurry of challenges, which have been consolidated in a challenge pending in the Eighth Circuit captioned as Iowa v. SEC. In late 2023, as the SEC's proposed rule was nearing completion, California enacted Senate Bills 253 and 261, which also imposed climate reporting requirements on certain companies doing business in California. These reporting requirements largely track the SEC's rule as proposed. But there was one big exception compared to the SEC's final rule. Senate Bills 253 and 261 included reporting on Scope 3 emissions, which had been omitted from the SEC's final regulation. That too was quickly subject to challenge in federal court and is pending in the Central District of California in a case captioned Chamber of Commerce v. California Air Resources Board. At this time, summary judgment has been fully briefed. Among the plaintiff's claims in that case are that California laws violate the First Amendment as compelling non-commercial speech on non-controversial matters, and that the California laws operate as impermissible de facto regulations on nationwide greenhouse gas emissions. Now for introductions. Professor Victor B. Flatt is the Coleman P. Burke Chair in Environmental Law and the Associate Director of the Burke Environmental Law Center at Case Western University School of Law. Prior to his coming to Case Western, he was the Dwight Olds Chair in Law and the Director of the Environment, Energy, and Natural Resources Center at the University of Houston Law Center. Professor Flatt is a recognized expert on environmental law, climate law, and energy law. He is co-author of a popular environmental law casebook and has authored more than 60 law review articles, which have appeared in journals such as the Notre Dame Law Review, Ecology Law Quarterly, Washington Law Review, Houston Law Review, and the Carolina Law Review. 7 of his articles have been finalists or winners of the Best Environmental Law Review Articles of the Year. He is currently serving as ethics advisor to the ABA section on environment, energy, and resources. Next, Trent McCotter is a partner with Boyden Gray, PLLC. He previously served as Deputy Associate Attorney General of the United States and as an Assistant U.S. Attorney in the Eastern District of Virginia. He currently represents Liberty Energy Incorporated and the Free Enterprise Chamber of Commerce in their challenges to the SEC's climate disclosure rule, currently pending in the 8th Circuit. He has also written about the SEC's climate rule for publications like Real Clear Policy. And finally, Stephen Hall serves as legal director and security specialist at Better Markets. Stephen's background includes extensive experience in securities and commodities regulation acquired through positions in the federal government, private practice, and the nonprofit sector. Mr. Hall oversees a highly accomplished legal team that files amicus briefs in important cases involving financial regulation, initiates litigation or intervenes in cases when necessary to advance the public interest, and provides regulatory analysis in the areas of banking, securities, and consumer protection. A sought-after expert, Mr. Hall has testified before Congress and currently serves on the Commission on Sanctions and Fitness of the Certified Financial Planner Board of Standards. Now, with introductions out of the way, I'd like to turn it over to Professor Flatt for his introductory remarks. Professor Flatt.
Thank you, Marc, and thank you to the Federalist Society for hosting this very timely and important event. Since I'm going first, I will also do a little bit of table setting. There are really 3 things I want to address today during our discussion, and only one of which of those is actually the focus, but the others I think bear on that. The first thing is, how did we get here? How did we get these specific rulemakings for the SEC and for California? The second question, which is really what we're here to talk about, are they legal? Or perhaps I should say, will they be adjudged legal? And then what is the practical effect of such a judgment? So starting with how did we get here, I think I want to say there are 2 stories that one can tell about how we got here. One story says climate activists are looking for any way they can to hamper or intimidate companies that contribute to GHG emissions. This story could start with the attempts to pass legislation at the federal level, specifically requiring publicly traded companies to disclose climate information, such as Senator Warren's bill of several years ago. And in the EU, where we have the double materiality, we look at not only how climate change affects your bottom line, but how you affect climate change. According to this story, when the Biden administration got in and had friendly members of the SEC and realized a bill wouldn't pass, they used their executive rulemaking authority to pass this rule. In this story, then, what you're seeing is a square peg in a round hole story, right? We're using the wrong thing in an effort to stop or limit climate change. Now, that's one story. The second story is this. Major investors began to be concerned about the impacts of climate change on the bottom line, particularly in 3 buckets: the impact on operations, possibility of government regulation, limiting greenhouse gases, and lower consumer demand for greenhouse gas emission products and/or products that increase the use of greenhouse gases. These are the very same buckets that the SEC's guidance on disclosure of climate risk mentioned in 2010. The major investor story is bolstered by changing consumer demands and requests from large institutional investors. These major investors were particularly vociferous starting in, I would say, the late 2010s, early 2020, and I would particularly note BlackRock, but one cannot fail to mention also the large public investors and major asset holders around the world. So to me, these 2 stories bear on how this will be viewed in a legal situation. In theory, the legal question is a little more straightforward. For the SEC, the question is whether the rulemaking is consistent with the SEC's enabling legislation to make rules to protect investors and have a fair playing field. And for California, and this is also one of the claims against the SEC, the issue is actually similar. That is, whether there's a legitimate, compelling reason to require this disclosure, and if there is, then it doesn't violate the First Amendment. So I'm not the Supreme Court, but to me, what the SEC is asking for fits squarely within its mission and is simply a standardization of reporting, which will be more efficient and ultimately easier and less burdensome on the business community in the long run. But of course, I'm not the Supreme Court. And I think the betting money is that if this gets to the Supreme Court, they may strike this down either under the major questions doctrine or as not consistent with the statutory grant of power. That may happen. That may be a higher than 50% probability that that will happen. But that gets me to my third point, which is the practical effect if that is done. And I believe the practical effect is that even if this rule is overturned by the court and the California rule as well, that's actually going to mean more work for American companies. The rest of the world isn't standing still. This reporting is already required in the EU. I think California's challenge on the First Amendment is weaker than the SEC ultra vires challenge. So companies are going to have to do this. In fact, many companies are begging for it. One particular data point I want to share is that between 2023 and 2024, according to Fitzy Russell, the concern about the ability to gather and report ESG data fell from 1 on the list of asset owner problems down to number 6. This same report noted that this was related to far less concern by major organizations about the ability to get the data on climate and the effects of standardization. International and American companies are also currently pushing for the ISSB standards, which are private, to be the reporting standard for private behavior going forward. The SEC, of course, did consult those in its own rulemaking along with the Task Force on Climate-Related Disclosures. I understand in a sense that this practical effect doesn't affect the legality, but I do think it points up that it may not be the right position to be taking that this doesn't really matter to investors. I think this practical effect shows it does matter to investors. And whether it matters to investors in turn, I do think affects the legal determination. Thank you.
Thank you, Professor Flatt. Trent, would you like to go ahead?
Thanks, Marc. So as Marc mentioned, my law firm is leading one of the challenges to the SEC's climate rule. So I'm biased. I have my own views on not only how that case should come out, but also what the argument should be and kind of what the better arguments are, in my view. To give a little bit more information for those who are interested in that case, currently the SEC's climate rule is actually stayed. The Fifth Circuit granted an administrative stay, in our case, before the multi-circuit lottery happened and the Eighth Circuit got all the cases. That lasted about a week or so, maybe a little longer. But afterwards, the SEC sua sponte stayed the rule, saying that there's a lot of uncertainty and they just wanted to make sure that the case could be orderly decided by the courts. My suspicion, I have no evidence, is that they were a little worried that the Eighth Circuit might grant one of these emergency motions to stay. And depending on how the court wrote it, that could be precedential and essentially resolve the whole case. And they didn't want to have this rule they'd worked on for years get stayed and kind of effectively torpedoed after just a month or so. So that's where the status of that case is. The briefing is now done in that case. There's been no oral argument date set yet. It's hard to predict exactly when it'll be, probably sometime over the next 6 months. And we can talk maybe later about the effect of the presidential election on the rule, if any. But kind of focusing on the litigation, so this is number 2, I think, in Victor's list, the legal arguments. My view, and this is how my team wrote the brief, is that the major questions doctrine is really the primary issue that the court is going to face. And I think it's, in a way, the hardest argument for the SEC to address. The SEC doesn't really dispute that the rule imposes nationwide effects. Even the lower estimates are $3 to $4 billion in costs, depending on how long you go out into the future. They also don't really dispute that climate change itself is politically controversial. Their argument instead is, well, we're not really regulating climate change, we're regulating disclosures, and that's it. We argue, well, that's kind of a distinction without a difference, but more importantly, even climate disclosures themselves are subject to a lot of controversy right now. I think maybe the most telling point, you don't want to set up some kind of automatic test, but the fact that the SEC received, they said 24,000 comments on this rule alone. They said it was a record. I don't know what the prior record was, but I imagine it's nowhere even close to that. So something that's attracting that kind of attention sure sounds like it might check a box for major questions doctrine. And to be honest, the White House isn't really helping the SEC here. The White House has said that climate risk is the most important issue facing humanity. They said it's worse than nuclear war. That's a quote from one of the president's speeches. And whether you agree with that or not, I think is kind of beside the point. It's more that this sure sounds like something that's really important. Sounds like something that maybe Congress would be the one regulating. Seems unlikely that Congress would let agencies regulate the most important thing facing humanity, at least without clear authority. It also doesn't help the SEC that in the past, they've largely taken the position that they did not have statutory authority to issue requirements for blanket disclosures on climate issues. They'd said that that would require new statutory authority, which has not materialized. Now in the final rule, they say, well, we never foreclosed that option. We just think the records change now. We think we've had this authority all along. The point is, I don't think anyone really disputes that this new rule is vastly different than anything the SEC has done in the past on climate, and that might be enough to kind of check that box on major questions. The fact that the SEC has seemed to have discovered a much greater power than it previously thought it had. So if that's right, and the SEC needs clear authority, they've effectively conceded, I won't say formally, but effectively conceded that they don't have it. The statutes that they cite all say that the SEC can mandate disclosures in the public interest. And there's a fight among the parties that's too detailed to get into here about how far that in the public interest language extends, reading other context, reading other provisions around it. But I think the fact of the matter is going to be, if we're in major questions land, the court's likely to say that in the public interest just isn't clear enough. In fact, there's a Sixth Circuit case from a month or so ago saying that exact same thing, in the public interest is not sufficient. So there's other arguments in the case, arbitrary and capricious. We can get into those sorts of things if people are interested. I think some of those have some legs too. I still think major questions, though, is kind of the preeminent point. It also is very appealing, I would think, to the court, because the court can look at this and say, this rule seems so different than everything we've seen in the past from the SEC, but we are worried about overstepping and cutting off the SEC's powers kind of unintentionally. And so how do we kind of target this one rule that seems so unusual? Major questions is perfect for that. There are also, as Professor Flatt said, First Amendment arguments. If I could just for a moment, our panelist was supposed to talk about the California law, was unable to make it. And if I could just have a minute to talk about that one. As Marc said, it largely tracks the SEC one. It's broader in some ways, particularly scope 3, maybe narrower in some other ways based on definitions. The problem with the California case from a challenger's perspective is that you can't really raise statutory authority or arbitrary and capricious arguments like you could against a federal agency. And so the Chamber of Commerce is the lead plaintiff in that lawsuit, and they're largely stuck with constitutional arguments, arguing that California is trying to regulate beyond its borders, kind of a dormant Commerce Clause argument, and the First Amendment argument, which is certainly in the SEC case. I think it's an important point. In my view, it's probably more of a constitutional avoidance point that the court should read the statutes narrowly so that it doesn't seem like the SEC can require disclosures on everything. I will note that in the California case, the district judge, the Central District of California, had scheduled a hearing on the pending motions for yesterday, and he took the hearing down. My understanding is that's not unusual in the Central District. They're very busy. They like to cancel hearings and decide things on the papers, but it could indicate that we're going to get a ruling quickly or soon anyway in that case. That's kind of the current lay of the land, like the most important points, I think. Back to you, Marc.
Thank you, Trent. Mr. Hall?
Yes, thank you, Marc. Thank you for the introduction. As Marc said, I'm Steve Hall. I'm the legal director and securities specialist for Better Markets. I think this may be the first time we've participated in a forum hosted by the Federalist Society. And we certainly appreciate the invitation and the opportunity to join the discussion. As Marc said, Better Markets is a nonprofit, nonpartisan organization that promotes the public interest in the financial markets through a variety of activities, including comment letters on proposed rules, amicus briefs, litigation, public advocacy, and congressional testimony. We filed a brief in the Eighth Circuit case in very strong support of the SEC's climate risk disclosure rule, and we advanced three core arguments, which I'll briefly outline. First, the rule is an appropriate exercise of the SEC's statutory authority to require company disclosures that are, quote, necessary or appropriate in the public interest or for the protection of investors, close quote. The rule will advance both of these goals. It will protect investors by providing them with more complete, reliable, and comparable information about the climate-related risks that companies face and how those companies are managing such risks. This is information that investors want and need to make informed investment and proxy voting decisions. The rule will also serve the broader public interest in accordance with the statute by promoting market efficiency, competition, and capital formation. Contrary to the challenger's claims, the disclosures are clearly material to investors. The rule is on its face framed in terms of material information. Furthermore, investors of all stripes, including investment managers controlling trillions of dollars in assets, have insisted that the information is material. And a long list of other governments and third-party organizations have similarly determined that such information is material and should be disclosed to investors as they allocate their capital and vote their proxies. Moreover, the disclosures are financially material to investors because climate risks pose ever-increasing threats to the financial condition of virtually every company in every industry sector. Our second argument is that the major questions doctrine has no application to the rule, with all due respect to Trent. First of all, the rule does not invoke a long unheralded power, in the words of the Supreme Court, or stretch the boundaries of the SEC's disclosure authority. Disclosure has been at the very heart of the SEC's mission since it was established over 90 years ago, and the SEC has been exercising its disclosure authority for almost a century. As a panel of the Fifth Circuit itself recently observed, disclosure rules are, quote, business as usual for the SEC, close quote. Moreover, the SEC has been specifically addressing the need for environmental and climate-related disclosures since 1971, 50 years ago, and then some. While the petitioners claim that the rule improperly casts the SEC as a, quote, environmental guardian, this argument obscures the distinction between disclosure requirements, which are central to the SEC's role, and substantive environmental regulation, which is left to other agencies such as the EPA. The SEC, in stark contrast with the EPA, is in no way attempting to regulate climate change itself, or even the way companies adapt to climate change. As the SEC explained in its rule release, it is entirely, quote, agnostic about whether or how registrants consider or manage climate-related risk, close quote. Finally, the rule carries nowhere near the economic or political significance typically found in major questions cases. And in any event, the rule satisfies the essential requirement of the major questions doctrine, since the SEC can indeed point to clear congressional authorization for the SEC to require disclosure of information from public companies and to update those requirements as the markets evolve. Our third and final argument is that the SEC fully complied with its duty to conduct an economic analysis in support of the rule. The petitioners have sought to impose on the SEC a duty to conduct a quantitative cost-benefit analysis where in fact no such obligation exists. It is well established that an agency's obligation to assess the economic impact of its rules is first and foremost a function of what Congress has instructed the agency to do. And the reality is that in the securities laws, Congress imposed only a limited duty on the SEC to consider whether a rule will promote efficiency, competition, and capital formation. Such an exercise, it did not rather require the SEC to quantify costs and benefits, and Congress made that decision with good reason. Such an exercise is an impossible task, as the costs and benefits of financial regulation are notoriously difficult to predict and quantify, especially when it comes to benefits. Imposing such a burden on agencies is simply a recipe for regulatory paralysis and endless litigation aimed at nullifying rules that are designed to protect Americans from all manner of threats to their health, safety, and financial well-being. In this instance, the SEC did all it was required to do and then some. It conducted a thorough economic analysis of the rule by evaluating its impact on the 3 statutory factors, and it furthermore assessed all of the costs and benefits of the rule, even quantifying them where possible. In sum, in our view, the SEC has issued an important rule that will serve the interests of investors and the securities markets as a whole. It complies with the securities laws, the Administrative Procedure Act, the U.S. Constitution, and it should be upheld by the 8th Circuit. That concludes my opening remarks, and I look forward to the discussion.
Thank you, Stephen. With those introductory remarks, before we launch into maybe unpacking further some of the kind of merits arguments against both rules, I'd like to ask kind of a table setting question of Professor Flatt. Professor Flatt, you said that this would standardize reporting, for companies, and for that reason, it would make it easier, make it kind of more efficient than kind of the status quo. And for that reason, there's support, broad support, at least among reporting or what would be reporting entities. Of course, Scope 3 was omitted from the SEC rule. Scope 3 is included in the California bills. And understanding that one argument against the SEC rules proposed in the California bills is that Scope 3, by sweeping in the activities and thus the emissions of upstream and downstream entities, puts burdens on those entities. This has become an argument, particularly among in the agricultural space. American Farm Bureau, which is a party to the California litigation, has posited that this could lead to consolidation in the agricultural sector. So when you say that there's broad support, is that among the reporting entities, which tend to be, which are publicly traded and by definition larger, or does that extend to the upstream entities that would have been included in Scope 3 of the SEC rule and are included under Scope 3 of the California bills?
Thank you. So primarily what I was referring to are the regulated publicly traded companies. So we are talking about large companies, the ones that we report, and particularly the investors in those companies. The investors want this information. And so if the investors are going to want the information, standardizing that becomes quite important, even if standardization occurs simply from the private sector operating at some point. Now, when you talk about the agricultural industry, you're talking about those people whose measurements would be included within a Scope 3 of, let's say, a company that was subject to either the California law or the SEC rule. And of course, not every company will be subject to those rules. So it is a very interesting question to look at the burden of data, right, in this instance. And this is a question that is threaded through both, again, private, just how people want to report information, how investors demand that information, and what they come to rely on. So if you were to go back and talk to a lot of companies, even 2 years ago, a lot of them would not have wanted to have to report scope 3. It was too difficult, right? It was considered to be too difficult to manage that. And so that means higher expense, right? It's going to be more difficult to do that. Now, in the interim, since the SEC actually proposed this rule, and it was starting before then, there are actually, we're in a capitalist society, so the private sector responds, right? There are companies that have created new algorithms to assist you in calculating your scope 3 emissions, right? In other words, it's like TurboTax. I think Persephone calls their model a TurboTax for emissions reporting. You just plug in some things and they spit out the numbers. And when you look at standardization, a lot of the scope 3 emissions cannot be measured directly, or it's too difficult to measure them directly, but there are what I would call sort of stand-ins for that can be calculated based on industry averages with some movement one way or the other. So I don't disagree that this can be a high burden. I also don't disagree that even if you're not swept up directly in the regulation, that if someone you provide to needs to disclose scope 3, they will be putting pressure on you to get information to them, right? That's going to happen. But it's already happening outside of this rule, even outside of the EU's rule, because investors are really demanding they do it. And so when I look back at the SEC rulemaking, I sort of thought it was an attempt, they're already saying it's material. This is simply an attempt to try to standardize it to make it ultimately easier for folks. Because they're going to have to, for the vast majority of large publicly traded companies, this information is in strong demand. They're going to have to provide it one way or the other. So sorry, that's a long answer to your question.
No, that's great. Thank you. And I welcome the other panelists to jump in. But since I asked a question directly of Professor Flatt, I do want to ask a question directly of Trent. Trent, given that climate change is a global phenomenon, greenhouse gases, no matter where they are released, have equal effect on the climate, more or less everywhere. There can be regional differences, but a molecule of carbon dioxide or methane released in New Delhi is the same as in New York. But by the same token, many of these reporting entities are multi-jurisdictional. They're not just doing business in California and several other states, but they're doing business, across the pond in Europe. And while it may not be an issue, I take it in the Eighth Circuit litigation, to what extent does that multi-jurisdictional reality of these reporting entities factor into, let's say, a major questions argument in terms of what is the actual impact and whether that's something that Congress actually needs to authorize?
Yeah, so I think there's kind of like a two-pronged response in terms of how this plays out. I think first, you're right that the SEC on major questions kind of has to walk a tightrope, because the more important they make it sound like this information is, the more critical it is to not just investment decisions, to kind of the nation and the world generally, the more it sounds like something that falls under the major questions doctrine, something that Congress would want to regulate. And one of the points that I neglected to mention in my introduction was that in the past, Congress has passed statutes on specific kinds of disclosures. They had disclosures about conflict minerals. They have statutes that require disclosures on executive pay, that sort of thing. And so that it cuts a couple different ways, but the fact that Congress thought that those were important enough to warrant their own separate provisions suggests, well, if climate change really is this global phenomenon with not just national but international effects, then it's something that maybe Congress would do the same for and say, here's how we want the disclosures. We're not going to let the SEC kind of just fall back on its generic disclosure power to do so. So I think that's a tightrope that a lot of agencies honestly have to face these days, is that they want to show that this is important and that it's necessary and that people really want it and it has incredible effects nationwide, maybe internationally. But the more they do that, the more it sounds like, at least to some judges, the more it sounds like something that Congress would have been regulating. On the kind of the second point, practicalities with these multi-jurisdictional corporations, I think that Professor Flatt's right that a lot of companies are going to be hit one way or the other. If they operate in the EU, they'll have to comply with that. If they operate in California and the California law survives, they'll have to comply with that. And so I think it's true that a lot of companies are compiling this information. A lot of them are publishing versions of it already. The SEC seizes on that to say, well, if companies are doing it already, it makes sense to try to standardize it. One thing that I thought was kind of a telling omission, though, from the rule, the final rule, and I think even the proposed rule, was that the SEC never cites any examples of investors who've actually been defrauded by what companies are doing already. Companies already have a separate obligation to disclose material information. That's kind of like an open-ended discussion that allows companies to provide more of like a narrative description. Here are things that we face that are material to the company. And I would have thought if the SEC really believed that investors were being defrauded because companies are putting out kind of unattested, non-official SEC statements about GHG emissions or climate risk that actually are very misleading, that they would have worked that in there. It would have been good examples for them to include, and they didn't do so. So I think kind of going back to the very original point that I think Professor Flatt mentioned, the two views of how did we get here, and there's one view, which is that you have kind of the climate activist or the politicians who just think people aren't talking enough about climate change. How do we make them talk about climate change? How do we make companies talk about it and think about it? And what they're doing already is not enough. And so that's why we end up with the SEC climate rules. I think it's true that if companies are going to get hit one way or the other, that kind of maybe reduces the harm from any particular rule. There are companies, however, that kind of model their business in such a way that they don't have to deal with places like California. Liberty Energy, my client, for example, doesn't really do business in California for this type of reason. It's so much of a headache. And maybe at some point, California will decide that it's not worth the lost business and lost investment. I don't think we're at that point. I don't think we're even close to it yet.
So, Stephen,
Marc, yeah.
Sorry, go ahead.
No, I was going to ask if I could respond to some points that Trent made, but you decide. I can offer up a couple things, and then if you have a specific question, I'm happy to hear that.
No, please jump in.
Yeah, three things I wanted to touch on, sort of push back on what Trent said on a couple of things. And the overarching point is that there are some fundamentally important distinctions that have to be made throughout this entire discussion and any debate over this rule. So, for example, Trent mentioned that the SEC is facing a challenge in the context of the major questions doctrine argument because it's the rule is deemed so important. But the distinction that matters here is that for purposes of the SEC rulemaking, they were very clear that it is important indeed, but to investors and to the financial condition and operations of public companies. That's bread and butter for the SEC disclosure regime. They are very clear on the record saying it may also be important to climate and climate change, but that's not what this rule is about. We are agnostic as to whether companies do or do not do anything to address climate change. So that's number one. The corollary is, to the extent that it is important to investors, that supports the argument of the SEC that it falls squarely within their disclosure authority. Two quick other points in response to Trent's observations. One is the challengers have cited examples where Congress has specifically tasked the SEC with disclosure authority, and the NAM case was cited. The distinction there is also often overlooked, but very important. Congress there avowedly was asking me or instructing the SEC to develop a disclosure rule for humanitarian reasons. So in a sense, it actually supports the SEC's position in this case. The SEC has broad standing authority to require disclosure from public companies. It did not have the authority to promote humanitarian interests around the globe. That's why Congress saw fit to pass a bill. It does not support the idea that the SEC is stepping out of its lane and needs congressional authority. The other thing that Trent mentioned is also a theme in the challengers' briefing, and that is that there are no examples of investors being defrauded when it comes to climate-related risks and issues. 2 points there. One, it's fundamentally beside the point. What we're dealing with here is a clear statutory authority in the 33 Act, the 34 Act, and elsewhere that the SEC has to put out disclosure requirements for public companies. It is not exercising its anti-fraud authority. That is not what this is about. That's a separate regime under separate statutory provisions. I will add that there are certainly cases of fraud and deception going on in the so-called green space, greenwashing and the like. But all of that is a separate matter. What we're dealing with here is clear-cut, unmistakable authority given to the SEC and exercised for almost a century to require disclosure. And that's what it's done here. That's the bottom line.
Can I just interrupt also very quickly in response to that last point and the point Trent made again about fraud or not? Even if you're really not talking about fraud, there is an example with the filing of materials. So there was an SEC 2016 investigation into ExxonMobil's alleged failure to adequately disclose certain climate financial risk based on its reserves. And in response to that, ExxonMobil did file an amended, I think it was the Form 10-K, that reduced its estimate of recoverable oil reserves by 3 billion barrels. Now, again, that's not necessarily fraud, but it does show that the concept of reserves matters to the company's bottom line, and that's one of the things that climate, this disclosure rule could get at. So I'll stop there.
I was gonna say one quick response. I think that Steve is right at kind of a high level, that a lot turns on how you view the SEC climate rule. Do you view it as like the ordinary disclosure regime that just happens to involve climate stuff, or do you view it as something else? And I won't go through all the details. I would direct people who are interested in my view, to read Commissioner Ueda's dissent when the rule came out, and he lists out a bunch of ways that the rule is different than typical SEC disclosure obligations in terms of how it defines materiality and the attestation requirements, things like that.
I want to follow up on the major questions kind of point, but first, returning to this question of, what authority exactly is SEC in its rulemaking exercising, and to what extent is it potentially a solution in search of a problem, or a solution that's long overdue? The federal government, both the federal government, a suite of agencies with either regulatory or supervisory authority over the banking sector, broadly defined, the FDIC, the Fed, others, did pilot stress tests of climate risk of the entire financial system, the results of which were disclosed last year. And without getting too far in the weeds, the takeaway, at least reading from a headline from EE News from May of this year, major banks tried to assess their climate risk. They struggled. That's the headline. I also know that the EU did similar stress testing, and one of the takeaways was maybe it's not as big a deal to the financial system as we thought. That was my takeaway, at least. So, Stephen, to the extent that is kind of a fair assessment of both kind of the European bank regulators and overseers and the American ones in these various stress tests, that A, it's difficult to measure at a systemic level, and B, to the extent we can discern, it may not be as big a threat as maybe some people say. Then if that's the case at the systemic level, what would be the argument at the individual company level that it's material to the extent that a institutional or individual investor would find that information material to the individual health, to the health of an individual company that's part of that system.
Well, I think the answer to your question is kind of embedded in the question. That you're talking about two fundamentally different issues. One is the challenge, as you described it, of trying to assess on a systemic or financial system level what sorts of threats of instability climate risk may pose. And that is, as you have said correctly, I think largely been the focus, albeit probably not enough focus within the realm of the banking regulators. This is fundamentally different. And the short answer, I think, or an answer to your question, really is that here, the record of this rulemaking is replete with evidence that climate-related risks have a profound impact and a direct link to the operations and financial conditions and prospects of individual public companies. That's what matters in this context. So separate and apart from that, I think there needs to be much more focus on the systemic implications of climate risk, but I think they're conceptually very distinct things. And the difficulties that may have been encountered in that realm, as you've cited, really do not undermine the relevance or the importance to investors of the disclosure rule the SEC has put out. And really, it's, I think, the professor talked about this. It's imperative in part because right now, access to climate risk-related threats to individual companies is just so difficult to assemble in a reliable and comparable form. And that's what the investor community is saying they need, in addition to the record evidence and the studies that show the link between climate risk and the prospects and financials, the firm financials of individual companies.
Marc, can I also interject one thing that relates to this? I appreciated you citing those stories about the difficulty of being able to measure the systemic risk and for banks providing data. I would just note that, but within the last 2 weeks, the European Central Bank itself in Frankfurt has made a point of cracking down on banks, they say, that are not sufficiently eco-friendly, if you will. And in their definition, those are banks that are not measuring their risk exposure to climate. And I think the quote they said is, even though it's, people see this as a very aggressive move on the European Central Bank, they say that their supervisory powers are to monitor how financial institutions are preparing for the worst economic effects of climate change. If they don't, or if they're overly invested in certain kinds of large greenhouse gas emitters, they can be exposed to risks of their prices, loans being returned, various other things. So, and again, Europe, by the way, is different. In Europe, they really do note that they are actually looking at trying to regulate because of climate, right? How do these things impact the climate itself, not just for investors? But again, the fact that the data is difficult hasn't really stopped other regulators from trying to gather as much data as they can.
Just to open the hood on this slightly, one thing that has not been clear to me and remains elusive in this space is the extent to which, climate risk, as kind of the regulators and the bank overseers see it, is tied to physical risk, right? The actual risk to assets, from, let's say, more extreme temperatures or natural disasters, if they are tied to climate change, versus so-called transition risk. The idea that, well, because of physical risk, which may present some risk, we know and we see that, multiple governments, including under certain certainly Democratic administrations in the U.S. and, in the EU are moving towards cracking down on greenhouse gas emissions through kind of various avenues. And because of those policy changes, people whose business is kind of exposed in a way to greenhouse gas emissions, they will have to get ahead of that transition, which means reducing their greenhouse gas, consumption or output and emissions. And to the extent that they don't, then policy will leave them behind, which to me almost seems like regulators and overseers front running policy, which to me, to the extent it's happening, seems like it might turn the equation on its head and almost give a kind of like inducing change that normally policymakers would make from bank regulators and overseers who either don't have regulatory authority or whose regulatory authority is normally understood to be much narrower. I don't know, Stephen or Professor Flatt, if you could address that.
So you ask a really important question. And I get what you're asking about at the end is like bootstrapping, right? Are they causing this by wanting the information itself? So you point out 2 of the 3 buckets of risk, right? I don't think anybody argues about, yes, companies can be affected by physical risk of climate change. We're seeing this with insurance companies right now, right? They insure people. There are other things as well. And actually, that's even their business model. You're also talking about the transition risk. And yes, theoretically, if there is more regulation of greenhouse gas emissions, there's more price on carbon for whatever reason, that will change the calculus of how much greenhouse gases can be emitted or should be emitted, which can change the company's bottom line. But the third risk, I think, that is slightly different from that is the risk that being associated or affiliated or being perceived as a large greenhouse gas emitter means that you will lose market share. And I have sort of 2 examples of this. And this gets to an issue of sort of what is the timeline? How far out are we really looking? So one example is if you look at, the big tech companies, right? Meta, Alphabet, Google, they all have been pushing very rapidly to go to net zero. They are getting their own renewable energy. They're doing this, et cetera. They are large energy users. But the reason they're doing that is to build a brand as a climate-friendly company because they believe, and I think they're correct on this, that it is important to their consumers and that they will lose market share if they don't have that. Now, you can compare that with some of the oil majors. So BP and Chevron, had announced plans to reduce their greenhouse gas emissions, both in their processing and their induced ones by their fuel they're providing and move more into renewable energy until the invasion of Ukraine. At that point in time, because of the, I would say, very likely, profits that could come, they sort of pulled back on those plans. And then officially, BP has pulled back on this plan. And since that time, then a lot of the large scale investors, like pension funds, et cetera, the British pension fund is a good example, have said they may pull all their investments from BP. I think maybe they're 5 to 6% of their investment. So, to the extent it matters to consumers, and there are a lot of consumers, that affects market share. Market share affects value of the company. Now, you may have a timeline distinction. Is it affected now, in a year, 10 years, et cetera? But it affects it.
Just a quick follow-up here. This is a question taken from the audience. We have a question and answer tab that you can submit questions to. We have 3, and I think one is a good follow-up to the point we've been drilling down on. Samuel Miller asks, can anyone provide concrete information about which institutional investors actually care about climate information? I work with sovereign wealth funds, and no one I work with evaluates this kind of information when making investment decisions. Very broad brush assertion, but to that point, we know that regulators care about it. Certainly BlackRock at certain points has cared about it. We have seen these kind of, I'll call them climate consortiums of financial, industry participants that have kind of come together and have started falling apart. around certain net zero pledges. But in terms of institutional investors that care, a concrete example maybe beyond BlackRock. I mean, they've certainly planted their flag several years ago.
Well, Vanguard, CalPERS, New York City Pension Fund, New York State Pension Fund, UK Pension Fund, Norway's Sovereign Wealth Fund has made position statements on both sides of that. I think that may be the largest sovereign wealth fund in the world. I'm not sure. And weirdly, even the Saudi Arabian Wealth Fund has talked about what they need to consider in terms of that. So pretty much any of the large retirement funds that are associated with, I guess, states that have a Democratic administration or cities that have a Democratic administration are involved in this. And BlackRock and Vanguard both, and those are the two largest, I think, investors at this point.
Could I chime in on that, Marc?
Certainly.
Yeah, I think it's a fair question, and I think one short answer, in addition to I think the very pertinent examples that the professor cited, is go to the comment letter file, and or go to the final rule release where the SEC exhaustively details all of the different voices from the investor side that have insisted that this rule is critically important from an investment standpoint. I also, if I could, just 60 seconds on your prior question, I thought that the risks that were kind of laid out and discussed were all correct. Physical transition, the consumer risk was a very important addition to the list, and regulatory risk. And I'm not sure exactly where you're going with your question, but I think it's important to note that regulatory risk is among the risks that the SEC has acknowledged in this context. And their definition of climate-related risk is very broad, and it encompasses all of these things, rightly so. But as a historical note, as far back as the early 70s, the SEC's early forays into addressing climate-related risks actually centered on challenges arising from compliance with environmental laws and potential enforcement of environmental laws and regulations. So it's not as if the policymakers are sort of getting ahead or jumping the gun. These are all extrinsic realities that ultimately affect company financial performance, and therefore investors want the information.
So, on that point, we saw in West Virginia v. EPA, the major questions doctrine, used to strike down the regulation under Section 111 of the Clean Air Act of greenhouse gas emissions from thermal power plants, electrical generating units. The Biden administration has recently issued kind of a replacement rule for the Clean Power Plan that again would use Section 11 authority, EPA Section 11 authority, to regulate GHG emissions from many of these same thermal plants, some both existing and some new, in a slightly different way. And that's already been challenged on an emergency basis. So there is kind of this headlong collision between the major questions doctrine and kind of how much work it will do in this space, or how applicable it is to regulations from various agencies in this space, and this question of regulatory risk and how reasonable it is, I think, maybe to bake it into some of these reporting requirements. That's me editorializing. But on that note, Trent, I would just like to turn back to you. Obviously, what Congress has said in duly enacted statutes is important to a major questions analysis. But there's also the question of kind of ex post congressional reaction to individual rules. And I note that there was a CRA, Congressional Review Act resolution introduced to void the SEC's climate disclosure rule. It was introduced in both houses. It passed out of committee in the House, 28 to 22. but ultimately did not receive a vote in the House. And likewise, it failed in the closely divided Senate. So what effect, if any, does this ex post reaction through the Congressional Review Act, in this case, to the rule, what lens or mood music does that add to the major questions analysis?
Yeah, both sides kind of cite the CRA action as being relevant. Honestly, I think it's more relevant when it at least passes one house, because it shows that it's on an issue of significant importance, that it was able to get legislators' attention and they're able to get it through for a vote. I think CRA votes come up in committee relatively often. It's hard to say whether this shows that Congress disapproves of the rule, or at the very least that Congress is thinking a lot about the issue. I think the SEC cites it and says, the CRA failed, so obviously Congress doesn't disapprove that strongly. I think it's honestly a little hard to draw much weight one way or the other in this particular posture. I would say one final point for me. I know we're right at the time on that. On one of our this discussion about who's asking for this information and whether it's actually useful and that sort of thing. This does actually play into one of our legal arguments for arbitrary and capriciousness. We argue that when you actually dig into the SEC studies that it cites, they don't really have any clear evidence that disclosures or even admissions actually affect corporate performance or stock performance. And there might be studies that show that, but a lot of the studies the SEC cites were kind of new, that hadn't been seen before. And so we raise an arbitrary and capricious argument on that basis too. A lot of people kind of assume these things affect corporate performance, but at least the record, as we saw, it wasn't so strong on that point.
Since we are running up against time, Trent, in terms of practical impacts, particularly the SEC litigation, could you provide a quick overview of the impact of the election, given that contingency, and how that may affect things going forward?
Yeah, thanks. I teased that in my intros. Thanks for coming back. So as I said, the argument date hasn't been set yet on the SEC case. At this point, it's certainly going to happen after the election. The 8th Circuit doesn't have another open sitting between now and the election. I think there's a fair chance that if Trump wins, that the court could just sit on the case and see what the SEC does. Is the SEC going to make moves to rescind the rule? And if so, why are they going to waste their time reading 1,000 pages of briefing and issuing a decision? They may not even have argument, for all I know, depending on how far out this happens. And similarly, if that happens, obviously, there's no chance of Supreme Court review in the end. If Trump doesn't win, then I suspect the SEC's I think they would stick with the rule. The 8th Circuit's going to have to issue a decision, whether it goes to the Supreme Court or not, is so far in advance, it's hard to predict.
And Stephen, if I could quickly ask you in terms of the practical impacts of the litigation and the contingency of the election and that uncertainty on compliance timelines, right? Because you file, in 2025 your 24 taxes, and 26 for 25. So what does it look like for reporting entities under the SEC rule in the upcoming year?
Well, I mean, the first point I think to make is that the SEC deliberately designed the rule with significant phase-in periods. And I think, therefore, the compliance burdens significantly mitigated between proposal and finalization are still down the road. I think, to your point about just generally the election, I wanted to echo with a variation what Trent said. It is, I think he and I would agree that the implications are huge, and the fact is that this kind of the who's in charge at the agency itself, who becomes the chair, who are the commissioners, that determines what a new and different SEC might do with the rule, and even how the case is defended ultimately. So the election has an enormous impact on not just the SEC's rule, but potentially other rules as well.
Well, it's unfortunate that we did not have our fourth panelist today to dive a little deeper into the challenge to the California bills. But I think we've had a really fulsome discussion today. So thank you, Professor Victor Flatt, Trent McCotter, and Stephen Hall for teeing up this conversation for us and really running through various aspects of both the merits and the practical impacts of the SEC rule. Climate disclosures is an issue that's not going away, whether it's the federal, state, or in Europe and in other jurisdictions. And I'm sure the Regulatory Transparency Project, as developments in both litigations evolve, will continue to update content on this very important issue.
Yes, and on behalf of the Regulatory Transparency Project, I wanted to thank this stellar panel of experts and also the audience who's tuning in live or listening to this at a later time. And for more content on important issues like this and other regulatory issues, please check out regproject.org. That's regproject.org. Thank you.
Thank you.